Hi everyone. Just going to wait for a few more people to join in and then I will get started. Whilst waiting, here's our lovely specialist social housing team here at House Percival. For today's webinar, you've got me, Estelle Corner, head of the social housing team. And this is the latest in our Housing Snapshot webinar series. Before I kick off properly, just to say there will be an opportunity to ask questions at the end, hopefully if I have enough time left. So if you could put any questions in the Q&A box. And if you've got any issues during the webinar, please use the chat function and we will try and help. So I will get started because I've got a lot to cover today. And for today's webinar, we're back to one of my favourite topics, which is shared ownership. And I'm going to cover some updates on some recent developments in shared ownership. So in this packed 30 minutes, first of all, I'm going to give an overview of Homes England's new affordability, eligibility and application priority guidance. I'm then going to have a look at some of the key points from the government's response to the Levelling Up Committee's report on shared ownership. And then finally, a quick need to know on the Leasehold and Freehold Reform Act and what it means for providers and particularly for shared ownership. Starting off, the overview of Homes England's new affordability, eligibility and application priority guidance for shared ownership. Now, I should stress this is an overview only. There's a lot of detail in the capital funding guide and the related documents, and I'm not going to be able to cover all of that today. So what is this kind of all about? At the most basic, it's about who can buy a shared ownership home and how much they can buy. And the fundamental principles in the capital funding guide haven't changed, but there is perhaps more of a shift of emphasis by Homes England. And there's an element of Homes England wanting to address some perceived bad behaviour by providers and addressing some kind of issues about leaseholders being financially overstretched. Homes England themselves describe the main changes as being removal of the Homes England calculator, an increased weight to provider assessment, providers having to provide greater clarity and transparency through published policies, use of a new affordability methodology and new audit requirements with sign-off sheets. The scope of this guidance, it applies to grant-funded and nil grant-funded shared ownership outside London only, and it applies to both first tranche sales and resales. So even if you're thinking, well, we don't do any shared ownership development at the moment, this is still going to apply to your resale stock. It won't apply to Section 106 schemes that are outside an affordable homes programme. But providers are going to want to think about consistency and having policies aligned so as not to confuse applicants and potentially not to confuse themselves. The new guidance was published in the Capital Funding Guide last month. There's a new Section 6B in the Chapter 1 Shared Ownership chapter. The intention is that there will be a transition period until the end of July for providers to get all of the new procedures and policies in place. And Homes England said the old guidance will be deleted on 1st of August. And from that point, they expect full compliance with the new guidance. Some questions have been asked about whether those timeframes will be extended because of the election. There were meant to be some workshops, training sessions that may well have been cancelled by Homes England. But there isn't a definitive answer to that I've seen yet. So at the moment, we are still working to the 1st of August. Turning to applicant eligibility, the basic criteria hasn't changed. So we're still looking at the gross household income of less than 80k outside London, otherwise unable to purchase a property for their housing needs on the open market. But what has changed is how that eligibility is determined. The Homes England calculator is going. The suggestion is that it had been used too rigidly. And so instead, the emphasis is being put back on providers to set their own policies of how to determine that applicant eligibility within the constraints of the Homes England guidelines. So ultimately, providers are responsible for determining eligibility of applicants, and this is a task they can do in-house or outsource to perhaps agents. Where they are outsourcing, providers should make sure they have appropriate legal agreements in place, and full records need to be kept of each decision made on eligibility for Homes England audit purposes. Applicant priority is something else that hasn't changed. The first come, first served policy has been there since 2016 and it is a grant funding condition. There are some exceptions to the policy, for example, protected areas where you can have rural priorities and military personnel. There is a suggestion that some providers haven't been following first come, first served and have effectively been cherry picking from applicants those who can buy higher shares and disregarding those who are only able to buy lower shares initially. So there is this renewed emphasis from Homes England on first come, first served, and providers are going to have a policy and a published policy as a grant funding condition. Providers are free to determine their own policy and work out how they are going to establish priorities, but the key is that priorities should not be influenced by the share that the applicant can afford. And Homes England have, again, stressed that they expect homes to be sold across a range of equity shares. A provider can have a target average share, but that must not be the minimum share that is sold on a scheme. The new guidance is very much focused on professional advisors and defining more clearly what is the role of a provider and what is the role of a professional advisor. So providers must use professional advisors to assess applicant affordability and the ability to obtain a mortgage. The professional advisor must be qualified and experienced and regulated to give mortgage advice. And that experience must be in shared ownership, and the advisor has to have access to a range of shared ownership mortgage lenders. And there are more criteria for advisors that are set out in the Capital Funding Guide. Providers could have one preferred advisor or a panel, use a panel of advisors, but whatever route they take, they should undertake due diligence on those advisors to make sure they are suitable and keep those appointments under review. And of course, there should be a legal agreement in place with those providers, with those advisors. It's worth noting that providers cannot require an applicant to take out a mortgage through the preferred advisor or through the panel. Applicants are free to use their own mortgage advisors as well. Providers may not get financial incentives from advisors for the referrals. And these financial assessments by the professional advisors must be at no cost to the applicant. But the applicant can be charged a fee by the advisor if the advisor does submit their mortgage application. Ultimately, the final decision on affordability and eligibility is to be made by the provider, but the providers must not overrule or unduly influence the advisors. So providers can't push the advisors to only recommend those people who can buy higher shares initially. Providers are going to have some new policies as part of this new guidance. There are two policies that are going to be grant funding conditions. So the first is the priority policy, the first come, first served policy. This is how providers will prioritise eligible applicants. As we've seen, this is up to providers to determine how this is best achieved, but they cannot be influenced by the share that is being acquired. The second policy is the monthly surplus income policy. So this is where the provider specifies the minimum amount of surplus income an applicant needs, and it can be expressed as a monetary amount or as a percentage. Homes England stress that this is a minimum policy and not a maximum, because providers are encouraged to have more flexibility and be less rigid about the amount of surplus income that an applicant can have. The idea is that applicants are allowed to have flexibility for future life changes and applicants should not be financially overstretched. There is a methodology for calculating the monthly surplus income in the capital funding guide. I'm not going to go into that in detail, but ultimately it is for providers to determine the appropriate level, taking into account their particular circumstances, for example, geographical area. Providers may also have other policies around eligibility and affordability, for example, a minimum deposit or an adverse credit rating policy. Additional policies must not conflict with Homes England guidance. And policies generally, Homes England have said they cannot disadvantage groups with protected characteristics, so you can't discriminate against people claiming benefits, for example. And Homes England have said that all policies must be risk assessed, reviewed regularly, and there should be a rationale retained. You should keep your reasoning as to why you came to particular policy decisions. With the assessment process itself, Homes England have said it's for providers to establish their own process, and this must be proportionate. And Homes England have suggested a two-stage process that might work where you've got a large development with a large number of applicants. Whichever process you go for, applicants should be informed of that process in advance. Providers can use their own tools for initial indications of affordability. So although the Homes England calculator has been scrapped, you can come up with your own calculator as long as you don't apply it rigidly and don't exclude, for example, applicants who are on the borderline. Applicants are still expected to purchase the largest share assessed as suitable for them. But as I've said, providers and advisors are meant to be taking into account future changes in circumstances more than perhaps previously. So they can look at future childcare fees, they can look at future care costs. And the aim is to avoid shared owners being overcommitted financially, being overstretched. You need to keep records and documentation for audit process of your assessment process and decisions being made. And you need to be very careful not to overstep the mark. Providers should not give financial advice that they are not qualified to give. Financial advice should only be given by your financial advisors. So the two-stage process that Homes England suggest may be appropriate in some circumstances. You've got stage one, which is the initial assessment, weeding out people who really aren't eligible to save them the hassle of going through the more detailed stage two. So that initial assessment is a high-level check on eligibility and affordability. You could use a basic calculator, and there is a sign-off sheet that Homes England has prepared, although use of that is optional. Stage two is the full assessment. So that's the proper detailed assessment of an applicant's income and expenditure. And there's information on the methodology in the capital funding guide. There's also a Homes England budget planner that is required to be completed, and a Homes England sign-off sheet. The information on that is again mandatory. And audit requirements. So as I've just mentioned, I've mentioned these sign-off sheets. There are some mandatory Homes England sign-off sheets. They are going to be part of Homes England audit requirements. Oh, my light's gone out. Sorry, going to have to try and turn that back on. So, yes, the sign-off sheets, the formal record of the assessment of the applicant. The precedents that Homes England have provided a minimum requirement, and you can do your own sheets as long as they meet those minimum requirements. And they should also be supported with additional information such as the Homes England budget planner. The sign-off sheets are meant to be signed by the provider, the advisor and the applicant. But if the applicant refuses to sign, you can provide evidence instead that you've tried to get them to sign and that you've sent the form to them. Ultimately, you're meant to be keeping evidence of your decision making for the audit trail and retaining evidence of your rationale for your policies. So as I say, there's a lot to take on board. In summary, at the moment, the key date for adopting the new guidance remains the 1st of August. The guidance applies to first tranche sales and to resales. Eligibility has not changed. but the Homes England calculator is gone. There's more onus on providers to determine eligibility and affordability and make final decisions. Make sure you're not overreaching. Don't give financial advice if you're not authorised to do so. And what do you need to be thinking about now if you're not already? You need to be drafting and publishing your new policies, the first come, first served policy, and the monthly minimum surplus income policy. And you also need to be thinking about any other policies around sales, minimum deposit requirements, adverse credit, etc. You need to be appointing your financial advisor or your panel of advisors, and you need to be audit ready. You need to have processes in place for your assessment procedures, your sign-off sheets and evidence of decision making. As I say, there's a lot to take in there. I've got some links at the end of the slides to the relevant Homes England guidance and publications. And there's also an email address there for Homes England where they've suggested that if you've got any queries, you can email them in. Moving on to another thing that happened in May. This is the government's response to the Levelling Up Committee's report on shared ownership. So back in March, the Levelling Up Committee published its report on shared ownership. It had 14 recommendations covering areas such as value for money, repairs, maintenance and fees, leases, shares. It was pretty damning about shared ownership. I've got some of the headlines on the screen there. Shared ownership is failing to deliver an affordable route to home ownership. Shared ownership needs urgent reform, unbearable costs, lack of affordability. But what was really disappointing on reading the report in detail is that it lacked nuance. It conflated issues with flats with shared ownership. So things that apply to flats irrespective of tenure, like high service charges, like cladding issues. There was no acknowledgement in the report that those issues don't affect all types of shared ownership. They don't have an impact with shared ownership of houses. So the government published its response in May, right at the end of May. Given the change of government that we're expecting in the next month, it's kind of difficult to know how much weight to put on that response. But I think, in my view, any new government would be brave to take a radical new stance on shared ownership and risk destabilising what is kind of really the only mainstream affordable home ownership product at the moment. So perhaps we will see the government response adopted, whatever. The report and the response are fairly lengthy, so I'm just going to highlight some of the key points, but I've put links to the report and the response at the end of the slides if you do want to go off and look into it in more detail. So one of the major recommendations was that service charges should be proportionate to the share owned. So if you own 20%, you only pay 20% of your service charge. Now, clearly that is going to have some pretty serious financial consequences. And the government's response to that recommendation was a fairly solid no. They did admit there were some valid arguments, but ultimately it was financially unsustainable. Another recommendation was to offer financial incentives to providers to voluntarily offer new model shared ownership, so 1% staircasing, repair holiday, 990-year lease terms on all new and existing leases. Again, the government's response was no. It was an outright no to offering a financial incentive, but the government did acknowledge that RPs are encouraged to voluntarily adopt new model shared ownership. There was also a recommendation that the government should come up with a plan to replace shared ownership homes that are lost on back-to-back staircasing. Again, the government said no. They said they would look at data, but ultimately there was no plan to come up with a plan to replace homes. Current delivery is sufficient. Some other things were looked on a little more favourably. There was the recommendation that lease extension should equally apply to shared owners. And the government said, yes, that is being put forward in the Leasehold and Freehold Reform Bill, which is, the Leasehold and Freehold Reform Act. There was a recommendation, well, there was lots of concern in the report about costs of older people's shared ownership after death, that family members have to carry on paying the rent and service charge. And the recommendation was that there should be mandatory highlighting of these OPSO legacy costs. So the government was kind of yes and no on that. They have said they would update the key information documents for OPSO, and they will also consider requiring providers to put that information on their websites. And the last recommendation I'm going to mention is for providers to have specialist teams of professionals to advise shared owners. Again, it was a bit of a yes and no answer. The government said they're not going to mandate that through the capital funding guide. It's not going to be a grant funding condition, but it may well be covered in the regulator's competency and conduct standards. So you may see that training has to be undertaken in shared ownership. So there might be some minor changes flowing out of this report. I say it is quite an interesting read if you have time, and the links are later in the slides. Something else that happened in May, the Leasehold and Freehold Reform Act came into effect. Now just going to call it LAFRA because it's too long otherwise. So a bit of a need to know about this. The Act got royal assent on the 24th of May in what is known as the Parliamentary Wash-Up, hence the picture on the screen. But ultimately, nothing has really changed yet. Almost everything in the Act, other than some minor stuff to do with the Building Safety Act, needs secondary legislation to become effective. So it needs more parliamentary time. It needs regulations or statutory instruments to be passed to go into the detail and to give commencement dates. And at the best guess, that secondary legislation is likely to be 2025, 2026, if it in fact happens at all. So what the Act did, it brought in a framework, a bit like the Levelling Up, a framework for change. And those changes, I think there's been a lot of talk about them already, but in terms of what's going to be relevant to shared ownership, we've got statutory lease extensions applying to shared ownership. We've got new valuation methodology for lease extensions, including shared ownership, standard lease extension term of 990 years. Leaseholder no longer pays landlord's legal costs on lease extensions, no more leasehold houses, with some exceptions, including shared ownership, and new standards for service charges and protections extended to freehold estate charges. The ground rent cap for existing ground rents didn't make the Act. But I stress again, there's lots of headlines out there about all of these things being in place now. They're really not. The existing rules still continue for the time being. So what does happen next? I mean, despite the picture on the screen, no presumptions, but if Labour have a majority in July, Angela Rayner has said Labour will introduce common hold legislation within 100 days of office. So Labour could go much further than LAFRA and abolish resi leasehold entirely, in which case maybe LAFRA will never come into effect, or perhaps there will be some secondary legislation introduced as a holding position. I mean, we just have to wait and see what Labour's policy priorities are going to be. The Renters Reform Bill, that was ditched during the wash-up, that may come back in some form. I mean, we just don't know at the moment what it is going to look like. So what should you or could you be doing now? Change is going to come in some form. So I think you could be reviewing your shared ownership lease extension policies, maybe preempting the law, maybe going a bit further with those. And you should be looking at your service charges and estate charges. You should understand what you were charging people and what you were paying to third parties. Make sure your house is in order, basically. All of this, I think, is quite a worry. Shared ownership is often an afterthought with this legislative change, and that can have some unintended consequences. One of which has come up in the past couple of days, and you may have seen on social media. So this is a bit of a PS to this webinar. Don't panic, but the sovereign case, it's a shared ownership possession case involving sovereign. It's come out of that shared ownership leases could be long leases for the purposes of Section 166 of the Common Hold and Leasehold Reform Act. So that Section 166 requires landlords to serve a prescribed ground rent notice before rent becomes due. So in the sovereign case, shared ownership possession case, the leaseholder argued no Section 166 notice had been served, rent wasn't due, no basis for a possession order. That issue has been remitted to a district judge, which means it's gone to a higher court for a full hearing. So there is no final decision on that yet. I mean, it all seems like nonsense. Shared ownership rent is not ground rent and really should not have been caught by these provisions. But on the face of it, on the face of that statute, it is caught. And these are the kind of unintended consequences of legislation not fully taking shared ownership into account. This case could have some very wide-reaching consequences for shared ownership. So it is something that we will be following closely and will keep you updated. That's my page of useful links. So that will come out for you all when the slides are circulated later. So we shall move on to questions. I can't see the questions. Let me see what we've got. Right. Let's see. On the affordability guidance, does it deal with cash purchases? Yeah, it does. There is actually quite a bit in the capital funding guide and the new guidance about cash purchases, although a lot of the new procedures are about availability of a mortgage and suitability of a mortgage. Homes England do stress that cash purchases are fine if the applicant can't get a mortgage, for example, due to their age or lower income. There is a separate sign-off sheet for cash purchases as well. Also linked to that, any further guidance from Homes England on whether unsecured lending can be used for shared ownership? Again, lots in the guidance about regulated mortgage lending. But there is a sentence where they do say that the government does not believe that applicants should be prohibited from using unsecured lending. So yeah, unsecured lending is in theory fine. I think that is all I'm going to have time for in terms of questions, but if there's any questions you've got that I haven't had time to answer, I will try and get back to them. I say we will send everyone a copy of the slides. There will also be a feedback form online. If you could fill it in, much appreciated. It really helps us to plan our future webinars. And of course, if you want to discuss anything in more detail, if we can help with any legal agreements for your financial advisors, if you need some advice on the possession order issues and the ground rent case, please don't hesitate to get in contact with me or another one of the team. In the meantime, thank you very much for joining me today. Take care and hope to see you on another webinar again soon.